Hi, my name is Mark D. Kopolis, and I'm a Philadelphia criminal defense and real estate lawyer. And today I would like to talk a little bit about the tenant eviction process in Philadelphia County, PA. I made a video that kind of highlights the eviction process 4 years ago. It did well. I received a call today from a landlord saying, I watched your video, but I'm wondering if anything's changed since the pre-COVID era, and I figured it was kind of time for an update here on how to evict a tenant in Philadelphia, PA as of June 26, 2024. The most substantial change that we've seen to the eviction process since the pre-COVID era in Philadelphia is the eviction diversion program. And this is a new requirement in Philadelphia that landlords must complete before they can even file for an eviction. Now, there are exceptions, and the exceptions to where the landlord does not need to apply for eviction diversion is where there's a risk of imminent harm or harassment at the property. So if you're a landlord, you're looking to evict your tenant and they're just not paying you, you need to go through the eviction diversion program. If you're a landlord and the tenant's there and they're breaking into other units, or they're breaking into the basement, for example, that's secured, or they're deliberately running utilities at the premises to antagonize you, they're running the water 24/7, or they're banging and making loud noises at all hours of the day and night, you may be able to forego the eviction diversion program and file your eviction right away. What is the eviction diversion program? It's basically a mediation session with the city of Philadelphia, kind of a third-party mediator sitting down with the landlord and the tenant to see if there's a way to work the case out before it actually gets to court. And the thinking is that if the eviction is filed, the tenant's rental history is going to be destroyed. And this is an opportunity for the landlord and for the tenant to resolve the case without the time and cost of litigation. And sometimes the eviction diversion program can be successful, and sometimes there's simply no choice but to file an eviction. One thing that's important to note about the eviction diversion program is that if you make an agreement through the eviction diversion program, it is not legally enforceable with a sheriff lockout. So for example, let's say you participate in a mediation with the tenant, and the tenant says, don't file the eviction, I'm going to be out in 30 days. If the tenant does not vacate within 30 days, you then need to file an eviction, wait 30 days for your eviction court date, and proceed with the writ of possession in scheduling the lockout with the sheriff. So while the eviction diversion program may be very positive for tenants because it can help them avoid an eviction record on their rental history, it can have downsides for the landlord because if the tenant decides to break the eviction diversion program agreement, the landlord then needs to file the eviction and basically start from there. Another one of the big changes that we've seen since kind of the pre-pandemic era is the existence of subsidized funds to help tenants pay their rent. And there's some landlords that really like these subsidized funds. They're happy to accept checks from the city and these third-party entities. And there's some landlords that just say, you know what, I'm a private landlord. I don't necessarily want the strings that are attached with this government money. A lot of times if you accept, the most common one is TFA, which stands for Targeted Financial Assistance, you cannot take any eviction action for at least 60 days from the date of the last month's rent that's been paid for by the TFA. So you accept these funds, and then if the tenant decides to default on rent or doesn't pay their rent, again, you're waiting to file your eviction and you need to get into eviction court to file the writ of possession and to proceed with a sheriff lockout. So in some ways, the eviction diversion program has been very effective. It keeps landlords and tenants sometimes out of court. Sometimes there's a way to work it out without the time and expense of litigation. And sometimes the landlord can even get paid. But at the end of the day, if you're the landlord and you need to get the tenant out of the property and you don't necessarily trust that the tenant is going to adhere to the terms of the agreement, your only option is to file an eviction in the Philadelphia Landlord-Tenant Court or some sort of removal proceeding in the Philadelphia Court of Common Pleas. So those are probably the two biggest changes that we've seen since COVID. In addition to that, you still have the rental license requirement, the certificate of rental suitability, the lead-safe certificate. One of the other major changes that we've kind of seen since the pre-pandemic era is the kind of resurgence of community legal services lawyers and basically pro bono lawyers who are now representing the tenant through city services. So pre-pandemic, there was usually a lawyer in the courtroom who was kind of designated to assist tenants. He would take up to 5 cases. That program has been kind of radically expanded to the point where now if you're a tenant and you're walking into landlord-tenant court, there is probably going to be a lawyer there to help you defend yourself. And conversely, if you're the landlord walking into landlord-tenant court and you're unrepresented, the chances that you're going to be up against a litigant, an actual attorney who's defending the tenant, even though you're pro se, is high and is probably going to get higher in the years to come, as the plan seems to be to eventually provide an indigent counsel or a pro bono attorney to every single tenant who comes through the Philadelphia landlord-tenant court. So you've kind of seen an increase since the kind of COVID era in rental assistance, in this eviction diversion program, kind of this opportunity using the government to work this thing out before it gets to court, and then government lawyers in court kind of regulating and monitoring these evictions that are being filed. And that's also resulted in an increase in counterclaims that are being filed by tenants in the Philadelphia landlord-tenant court. There's a lot of tenants who they receive their free counsel, and then in an effort to either negotiate with the landlord or perhaps to recover back rent that was paid, they will then file a counterclaim against the landlord to assert their tenant rights, alleging, a violation of the Philadelphia lead disclosure law or habitability or wrongful use of civil proceedings, something to that effect. And we have seen cases, not that we represented on, but that other attorneys represented on, where the tenant won the case in landlord-tenant court and then turned around and sued the landlord for violation of the lead disclosure law, for wrongful use of civil proceedings, and actually filed a substantial lawsuit based on what happened in landlord-tenant court. So it's important to take these civil proceedings seriously. A lot of people think it's municipal court, it's not a big deal, I just got to go in with my signed rental suitability and my license and I'm going to be okay. But there can be serious ramifications if you don't take it seriously, because you may end up getting sued. You may find yourself up against a tenant who's represented by an effective counsel. And if you lose the case, the tenant may turn around and sue you for wrongful use of civil proceedings, or for violation of the lead disclosure law, or for a related ordinance violation, or they may file an appeal and take the case into the Court of Common Pleas. So it's important to be wary, if you're a landlord, of changes in the landscape, so to speak. The kind of the issues that I've discussed are some of the biggest developments that we've seen since COVID. One of the major positives that we've seen is the time frame to process an eviction has gone way down. So in 2021, obviously 2020, there was the eviction moratorium. Even when evictions started to happen again, they were moving extremely slowly. It was taking 9 months to a year to remove a tenant. In 2022, 2023, there were issues with the sheriff where the Philadelphia landlord-tenant officer was involved in multiple incidents where tenants had been shot at the property, and their disposition time to remove tenants had increased dramatically. Here in 2024, the time frame to process an eviction as of June 26, 2024 is pretty reasonable. You're looking at about 3 months to get possession of the property, and that's if you complete the eviction diversion program. Whereas if you just file as saying there's an imminent risk of harm or harassment, you could potentially do it in even two months. But again, you'd have to be able to prove by a preponderance of the evidence that the tenant is either destroying the property or is really causing problems at the premises. So that's kind of a kind of short discourse on the developments in Philadelphia landlord-tenant law since 2020, 2021, the COVID era. My name is Mark D. Kopulis. I'm a Philadelphia real estate lawyer. I handle evictions in Philadelphia County as well as civil and criminal defense matters. If you own real estate and you're looking to file an eviction, or if you've been sued by a tenant for a premises liability action, or for a violation of Philadelphia code, or for some related property dispute, feel free to give us a call for a free consultation. My direct line is 267-535-9776. As always, thank you for watching my blog. If you have any questions, don't hesitate to give us a call, and have a great night. Take care. Bye.